So the title of our panel is What Did We Miss? And I've been listening to the conversations today and listening to and discussing with the panelists about where we're going, and I can pretty much guarantee you that it's going to be very broadly and loosely and interestingly interpreted what did we miss, because a lot of it's going to be about what we should have done, maybe what we did do, maybe what we could have done, maybe what worked, maybe what didn't work. Maybe some big ideas about where we should go next. We're going to be all over the place, and I think that's great. We asked you a couple of questions to start off with. Put those out in the email that Victoria sent out earlier this week. The two questions were, what barriers have you experienced in moving research into practice, and what opportunities have we missed? We didn't get a lot of response, so if those are questions that you have answers to now, at the end of the panel, feel free to bring your thoughts forward, or other thoughts. I'm Jacquelyn Burkell from the University of Western Ontario. I am not a lawyer, I'm a cognitive psychologist by training, so I think about these things very differently, but we have 4 people on the panel who, all of them are lawyers, I believe. No? Okay, most of us are lawyers, but we certainly work in the legal field and doing research in the application of AI in justice system. We have with us, and I'm just going to briefly say the order in which people are going to be presenting. We have Catherine McKinnon from Justice Canada, Ayelet Sela from Ilan University, Karine Gentelet from Université de Québec en Outaouais, and Giampiero Lupo from the Italian National Research Council. And without any further ado, I'm going to call up Catherine.
Thanks very much, Jackie, and good afternoon, everyone. I work in the Access to Justice Secretariat, which is a small unit at the Department of Justice Canada. And we have a mandate to advance what we call a people-centered approach to justice. So we've been hearing a lot of, let's not talk about human in the loop. Well, we don't. We talk about people at the center. So that's going to be a lot of my focus in my remarks this afternoon. And I am really honored to be part of these important discussions. So over the next couple minutes, I want to quickly share a few research findings related to the broader context of the ongoing access to justice gap in Canada. And it's going to be looking a lot at what are the problems that people are facing and what are their experiences like with technology. I'm really just going to be touching the surface with these points, and I know that my fellow panelists will be delving more deeply into a few specific areas of interest. Oh, and I'm supposed to be pushing this button. I'm really bad at technology, so I'm hoping things work. And we'll move. Okay, good. So first of all, I wanted to highlight a bit of data from our latest legal needs survey, which was included as a component of Justice Canada's National Justice Survey in 2025. And it reveals that 39% of adult Canadians experienced at least one serious problem that was hard to fix in the previous 3 years. So that's millions of people. Earlier data from our 2021 Canadian Legal Problems Survey that Statistics Canada conducted for us provides some further detail around who is experiencing these problems. And it found that a higher proportion of Indigenous people and Black people reported experiencing at least one problem, and people with disabilities were much more likely to experience a cluster of 3 or more problems. The most common types of problems that were reported across both surveys included things like neighborhood disputes, poor or incorrect medical treatment, discrimination, and harassment. 40% of people experiencing a problem searched the internet to try to resolve it. We can compare this to 28% who contacted some form of legal professional and only 10% who contacted a court or tribunal. So people are clearly looking to the online world for help and often are not seeking assistance through the formal justice system. Unfortunately, over 60% of respondents reported their problem is still unresolved. And what did people say they wish they had to help them solve their problem? the number one choice was services that better respond to their needs, pointing to the importance of a people-centered approach that provides flexibility in the justice services and pathways that are available. Okay, so this is certainly the case when it comes to the use of AI and technology. And our 2021 National Justice Survey reported that First Nations and Métis respondents were less likely to be comfortable looking for information online than non-Indigenous respondents. And similarly, Black respondents were less likely to be comfortable than white. We're curious as to whether these comfort levels have shifted since the pandemic. I suspect they have, but that's to be tested. So we hope to include some questions around this in our next National Justice Survey, which will be conducted early next year. We do know from more recent research that the National Self-Represented Litigants Project undertook in 2024 that the experiences of self-represented litigants with virtual justice have varied. Approximately 24% of the self-represented litigants surveyed were satisfied with their virtual hearing. About 35% were not. And we were hearing about the experiences of self-represented litigants earlier today in the case of hallucinations as well. So clearly some barriers and challenges with people without legal representation. As the authors of the National Self-Represented Litigants Report indicate, virtual hearings are not a one-size-fits-all solution. And research on justice services for the elderly and persons with disabilities also point to the need for options. The digital divide can disproportionately impact these diverse communities with income, digital literacy levels, and geography, affecting access to technology. And as just one indicator of this divide, I was looking online, and Innovation, Science and Economic Development Canada, so ISED, reports that more than 90% of Canadian households have direct connection to high-speed internet. And this seems encouraging until we see the number for Nunavut, which is 0%. Another recent research initiative or research finding comes from a 2025 global study on trust, attitudes, and use of artificial intelligence, which was conducted by KPMG International and the University of Melbourne. This study found that Canadians have among the lowest levels of training, literacy, and trust in artificial intelligence systems in the world. And they're looking for better education and strategic oversight. So very much in keeping with what we've been hearing today. Of course, some degree of distrust is healthy, as we know. AI can be biased and perpetuate discrimination, can also disseminate and amplify misinformation. But if our goal is to support the development of trustworthy AI and other technological tools that support improved access to justice and are responsive to people's needs, what can we do? And I would suggest that the key elements of people-centered justice, can give us some guidance in how to do this. So first, we should look at the data and consult people themselves to better understand their experiences with justice problems. The OECD has identified the need to involve intended beneficiaries in the design of AI services, and this is very much in alignment with the recommendations, as I understand, coming out of Subproject 11. We should also consider the evidence of what justice interventions work. The OECD advocates for the use of systematic mechanisms to collect and analyze data on AI's impact. A people-centered approach would also ensure that people are empowered, and we were hearing a lot about this earlier, to understand and use the available tools. The National Self-Represented Litigants Project and others have flagged the need for education and training that will provide individuals with the capacity to assess the reliability of digital tools and use them appropriately. And we should promote multidisciplinary and cross-sectoral collaboration. And again, common messages from throughout the day. There are lessons that can be learned about how AI and technology are expanding access to healthcare, for example, or not. So knowledge exchanges across sectors could be very beneficial. So, as I noted at the beginning, this is just a sampling of research findings in this area, but I hope that it's provided a bit of a sense of the access to justice challenges that people seeking justice are continuing to face, and how a people-centered approach might guide our response. I'm looking forward to the discussion ahead and hearing from my fellow panelists. Thanks very much.
So it's great to be here. Thank you for the invitation. And even though it's the last panel of the day, I think it's a fun panel because we get to try and ask what's not working well. And I was actually pleased because throughout the day, a lot of the issues that we are covering in our panel have been addressed by some of the former speakers. So hopefully we can add something new to the mix and build on some of these earlier discussions. So in my presentation, I'm going to focus on access to justice technologies in courts, and particularly the promise that AI had to deliver better access to justice in courts. And I base some of these data and arguments on work that I've done while at Stanford last year and continuing now, on the way courts in the US, and particularly also the Los Angeles Superior Court with which we're working, are using or are trying to use AI in their courts. Surveying the way that courts are using or can be using AI is quite challenging. Hopefully to this audience, many of the different uses that are listed here on the presentation are familiar. I want to focus on the fact that the promise of AI in courts has to do both with improving the way justice is administered by the organizations themselves, by courts, whether these are administrative tasks, which are very important because we can better use the human resources of clerks and support staff of legal help offices within courts, and also, of course, judicial tasks, as the previous panel has addressed. But it's also, and many of the presentations focused on this today, empowering self-represented litigants to better access a system that has a lot of barriers, or that sets a lot of barriers ahead of them. This has to do with using AI for navigating the system, for educating the self-represented litigants on their rights, translation, maybe even mapping legal issues that are relevant to their case. And of course, as we've discussed here earlier today, also online dispute resolution, actually resolving the disputes that they have in court using online tools. So why isn't AI delivering yet on all of these promises? And I think the audience in this room is already convinced that it could, to some extent, do that. I want to propose several explanations, and I want to suggest that in some of the work that we've seen here today and this project has done, we've missed some of these issues. And the first one has to do with the fact that when we're talking on access to justice problems in courts, we are talking about lower courts, so this would be state courts, municipal courts, local courts, where most of the people actually access the system. These are the largest dockets in most court systems. And this is also where we typically see the highest rate of self-represented litigants that are trying to access the system. In the US, in state courts, the model case is a case where we have a self-represented litigant. Oftentimes that litigant is facing an institutional actor, a repeat player, that is, whether this is debt collection or evictions, sometimes also in family proceedings, foreclosures and so forth. And so a lot of what I'm going to talk about has to do with the problems of these lower courts. The first problem has to do with court data infrastructure, the fact that courts, you know what, I'm going to first review them all, court data infrastructure and the technical capacities the courts have. The second is immature AI, or the fact that AI is just not there yet to deliver on many of the tasks that we're talking on. And that has to do with the limited scalability because we still need a lot of human involvement in the design of different AI-based tools for them to actually be effective and trustworthy for users to use. Third, on the ground, and I'm wondering, I didn't get to ask Eric this question, we see fairly low user uptake of court-sponsored tools. This has been so traditionally for legal tech tools offered by courts, like guided pathways and so forth. And I wonder whether that's going to transition also to AI-based tools. And it has to do also with cultural barriers and legal barriers within courts, the unauthorized practice of law that was discussed here earlier today, the duties of judicial neutrality that hinder some of the initiatives of court-sponsored AI tools. And finally, this broader question, which I hope we can focus on later in the discussion, which is when we're trying to automate bad procedures or bad law, systemic problems that are very prevalent in our legal systems, and we're hoping that, oh, we're just going to put AI in there and it's going to automate all these things, and then these systemic problems and these bad laws are going to go away. It just doesn't work. And so we can ask, well, what can we do about that? I know we don't have a lot of time, so I'm going to skip through some of these things, and I'm happy to share my slides with anyone who's interested in doing that. I'm just going to say this. For lower courts, especially in countries like the US or Canada, or where we have federal systems, where we have many different court systems with different technological infrastructure and with different legal frameworks that are determining the way cases are handled, we have a huge data problem because this data is not standardized, it is very fragmented, and even within a single court system, we may have one provider for our case management system, another one for our filing system, another one for our self-help system, and so forth. And these systems are not integrated because we don't have good data standards. And so at the end of the day, when we actually want to analyze data and we want to see some workflow and draw some inferences from that workflow, there's a lot of added processing that has to go into that for it to be functional. Now, this is a challenge, of course, for AI-based systems. And it is a challenge for court IT departments, which actually don't have the bandwidth to handle this. It's very costly to bring in external staff to do that. And any integration of the system and training of the system within courts is actually very costly and is sometimes the obstacle for adopting a good AI system that could work. I'm not going to say much about immature AI because we talked about it throughout the day so much. We know that evaluating the quality of outputs of AI for their accuracy, for their completeness, is an ongoing task. Today, still very limited to specific tasks, oftentimes simple tasks to particular legal domains, particular types of users, particular technologies. We've recognized here today that the level of risk is very different for different users. It's much higher for self-represented litigants that lack the expertise. It is perhaps less risky, perhaps because we've discussed this, for expert users like lawyers and judges. But that is still an ongoing endeavor. So accuracy still remains an issue. The sensitivity to prompts is still an issue. I'm not going to touch on that because we've talked about it so much today. I do want to highlight another issue, and I'm wondering whether some of our legal tech partners here in the audience would have something to say about that, which is, what are we missing? We've talked about law being a text-based discipline or a profession. Most of what lawyers do is documented, allegedly. Most of what courts do is documented, allegedly. But the fact of the matter is that it's not. And so much of the normative content of the law, analogies, reasonings, even intuitions that lawyers and judges use in their work processes is not documented in the text. And this layer of tacit legal knowledge is missing and is oftentimes perhaps the missing link for these systems to actually operate at a level that is comparable to a human-produced output. We still lack methodologies for capturing that tacit legal knowledge, that human element in the production of legal outputs. And until we have a scalable technology to do that, maybe with agentic systems that interview lawyers about the outputs, maybe in other ways, that's going to be something that's not allowing those legal outputs to be comparable to those that we expect of human service providers. Okay. Low user uptake. So I've mentioned earlier that there's a lot of money and a lot of effort that goes into the design of human-facing legal tech and AI-based tools, and not enough measurable uptake, actual usage of these systems. I'm happy later in the discussion to share some data on that on other contexts. And we should question ourselves, why? We're putting so much work, so much effort into tools that are eventually not used in practice and are not moving the dial on actually solving access to justice problem. And maybe this relates to Catherine's presentation, right? Maybe because many of the users are not actually capable of using them. These are the users that are most vulnerable, that we do want to offer the most help to, and yet these tools are not catered towards their capabilities for a host of other barriers, not all related to technological efficacy. Some of them are just your run-of-the-mill access to justice barriers that are preventing them from using this technology. I'm going to talk about what I think may be a solution for that in just a couple of slides. We've said this earlier today, so I'm just going to mention it, that until we solve the unlicensed practice of law problem, this distinction of what AI tools can actually provide to their users. Is it just legal information? Is it also legal advice? For most users of these tools, what they need is an action plan. What do we do next? And until we have tools that can actually provide that within a legal framework that supports it, the potential of these tools is not going to be maximized. This distinction between legal information and legal advice is possibly not holding true anymore, especially in an age where your typical AI tool will already offer you also next steps for action. And I want to relate this to the regulatory reform effort that's underway in some countries, in some jurisdictions, and I think we need to expand our thoughts on that, not just how lawyers and non-lawyers can collaborate, but also how can we create more professions within the legal ecosystems that can use perhaps AI support tools in order to deliver services better, to augment or to enlarge the audience that can actually enjoy the benefits of this AI, possibly solving also that conundrum of different risk levels for different AI users. I want to say one last thing about automating bad laws and systemic problems and this idea that AI can't fix them, and a call for action of what is our role, even though we're here in the justice tech audience with this respect. So we may have guided pathways or AI-supported smart interview and phrasing tools, but if we don't solve the problem that very high pleading standards are problematic, or that we have very short answer deadlines for some case types. So for example, in California, for an eviction case, until recently you had to respond within 5 days, or you would get a default judgment against you. Now it's 10 days. But it's still 10 days where you need to produce very complex answers. Most people, even with great guided interviews, can't complete those guided interviews within that framework of time. Filing fees, answer fees still remain a barrier, even if we have a great AI tool to produce them. And the systemic gaps that we've discussed here between repeat player, represented litigants, and these one-shotters, non-represented or self-represented litigants also permeate the system, and until we solve them, technology is going to serve more those who are represented and are repeat players than others. Legalese, procedural rules that are designed for trial, even though in so many countries, in most countries, trials are so rare. There are only 1, 2, 10 of the cases, why won't we make these processes simpler? So we wouldn't need these complex guided interviews or chatbots, and we wouldn't need translation from legalese to plain language. And if we solve these problems, perhaps we could focus AI on where it's actually needed. And finally, this may have to do with the last panel's discussion. The way that the system works today means that we have very inefficient and very inequitable judicial attention allocation. Judges don't see most of the cases of which we're actually talking about here today, right? Because these cases don't make it to a hearing or maybe even to a judicial decision on the merits, even if it's in writing. And so fixing some of these systemic legal problems doesn't have to do with AI, it has to do with broader reform. I see I'm already way over my time, so I'm just gonna put this slide, which is what can we do about it? And I said one sentence about each one of them. So maybe the paradigm of empowering self-represented litigants themselves shouldn't be the only governing paradigm. Maybe augmenting the way legal help is provided to self-represented litigants is a better way, at least until we solve the quality, completeness, UPL problems that are currently limiting us. Can we change legal education? And this has to do with the previous panel, so that we have better legal knowledge engineers, better prompt engineers coming out of law schools. Maybe we have other people be trained in law school that can provide some of these services, and this has to do with the UPL restrictions. Can we harbor a better data-driven culture within courts, administrative tribunals, other administrative agencies, so that we can do more with their data? And this has to do with changing some of the business processes, some of the workflows. It means that at the procurement stage of different data systems that they're using, they're already taking into account the way that we want to use the data in order to improve access to justice and in order to study it. Service pluralism, I'm going to put aside because it was mentioned earlier. I'll just leave it at that. And I want to say one last thing about reimagining justice and not just automating it. There is so much upstream potential for AI. If we actually committed to improving access to justice and actually justice itself, perhaps we shouldn't be worried about how do we help people once the problem was already formed. But we should take this data, we should take these tools, and we should understand how the problem emerged. And we should use our data in order to solve these problems earlier. A lot of the diagnostic work, the pathways work, the problem identification work can be done earlier in the process so that we avoid all these disputes and legal problems emerging in the first place. This has to do with thinking about how we digitize earlier aspects of the business process, not just the end piece of resolving the problem. So I'm going to stop at that, and happy to discuss more at the Q&A.
So I was in charge of a sub-project about empowering. It was titled as Empowering Marginalized People, but what I did is research asking people what is justice for them, especially justice in AI context. So I put it broadly. By the way, I'm a sociologist, so trained in anthropology and sociology, so I don't have anything to do with legal, I don't have any legal expertise. I don't want to have legal expertise. And also, I'm sorry, but I'm going to use sociology wording to describe brutally what I think about. So don't throw any rocks at me. I'm going to talk about the big picture of justice. And during this research, we asked people across the world, what is justice for you when you think about justice in AI context? And I want to point to this picture that I love. She's not working towards cyberjustice, Karine Gentelet. She's not moving backwards. She's taking justice with her, and she's going to do her own things. And this is basically what we found in that research. So when you talk about justice, in fact, people say it is social justice. And when we ask what motivates people when use AI digital technology, depending on the region of the world, it's only digital, not AI necessarily, but you see that there is nothing about access to court. This is violence, ineffective democracy, you have AI issue, algorithmic discrimination or injustice, disparity of language, but this is basically societal challenge, systemic issue, not technical or judicial issue at all. Big why? Because in fact for people, when you talk to them about justice, it means social justice. And when you think about the justice system, or when you think about the concept of justice for them, it's social justice. And it's not only justice, but the injustice they are facing. And they really put in that kind of word. So what they want, and I don't know if you have participated to a protest lately, when they chant, what you want justice, when you want now. So basically this is people what they are saying. So they say, okay, we are living in social system, we are social individuals. So what we want is a solution that tackle our social issues, social injustice, social discrimination. The second one is to understand exclusion mechanism. If we want to talk about inclusion, include people, especially marginalized people, but also self-representative litigant, we have to deconstruct the exclusion mechanism. We cannot include people if you don't understand what exactly has been excluding them. And this is something that sometimes we don't miss. We go straight forward to the solution that we want to develop, AI, digital tool, whatever, but not look at the exclusion mechanism. So I think at some point we need to take a step forward and exactly do what a very famous sociologist here, Guy Rocher, do, is like to take a step forward and have like, in French we say, regard oblique, like you look like that and you try to have the right angle to understand the structure behind exclusion. Because why? And a lot of people have talked about that. You have pre-existing inequality, and it's valid for any kind of system, but especially the judicial system. You have increased digitalization of interaction, dématérialisation, as we say in French, and you had amplified digital exclusion. So the understanding of exclusion mechanism is really important if you want to put anything forward to include litigant. The last one is citizen engagement. We talk a lot about solutions, what could be done for lawyers, what could be done for judges and for the system, but what about the citizen? And I'm not talking about litigants, self-representative litigants, not when they are into the system, but just a citizen. And what we are talking about right now is the fact that the AI governance, so not only in the justice sector, but the AI governance is in need of trust, transparency, accountability, and there is a strong push to include citizens and to engage with citizens just to make sure that we respect that values of transparency, trust, and accountability. So I think at some point this is really something that should be done and engage with citizens. I know that some people with Educalois have developed some tools, and my colleague Kate also talk about that. When we talk to people, okay, what would it need for you to be included or to participate in kind of in tools into the justice sector, but also in other kind of tools? Oh, there is a typo. They say you need to take our lived experience, our own reality into the core of any kind of process of design of even deployment. This has to be stick to our needs and to the solution you need to tackle to that. So you need to talk to us, and you need to talk to us in a way that we understand and we can contribute through our lived experience. Also respect agency and autonomy. People say we are, even the marginalized people, I did some interview in people in rural India, I did some interview in people in Africa, and they say we are in capacity to act upon our own needs and to find and to help you to find the solution to address our need or our issue. So we are in full capacity to contribute. Doesn't mean the contribution has to be 100% from A to Z, but at some point we need to have a view of what you are doing. Take also the social fabric and the collective dynamic. And behind this is the power relation inside any kind of communities or country you work in. And it will mean that to have collaboration with civil society. This part is really super important. Why? Because most of the time civil society know exactly what the issue are. They are like the mediator between, populations and the state, for example, and they are really a good actor to engage with and to, for example, do some consultation, participatory workshop or deliberation processes dialogue, for example, and you can rely on them. Also, they say, okay, we can suggest toolbox. And the first one will be do some education about digital rights. And most of the time, people, when you have some education about digital rights, it's like separate between digital rights and human rights. And people say, no, we understand, but we think that digital rights are human rights, and we need to have education about the two, how it could be linked. Why? Because we want to also understand what exactly is going on with our rights and what kind of rights are being affected and impacted when we go forward and we want, for example, to have redress on any harms. Also, what they suggested is can we describe our harms post at least or ante. So don't talk about risk, but talk about what should happen to our rights. Can you develop also collaborative spaces and cooperation mechanism in design also and deployment, and they say in the governance also. And we also spoke with initiative developed locally using AI, using digital technology, and it was super interesting to see that their governance model was very horizontal. So the trust between the developers and the population was really close. They were close together. Most of the people developing were from the community, for example. So there is a very deep trust between those two actors, and a very continuing process from design to deployment because of that horizontal governance model. And also the last one, and I always say that this is the most controversial maybe, is that people say when we are affected, when our rights are impacted, we need to take action and go to the courts. So it's very interesting because for them, going to court is at least the last step of any kind of injustice and any kind of harm they could face. But they say we need to be able to take action. And actually, when you take, for example, in Canada, there is no I don't know the word exactly, so don't throw any rock at me, but recourse, you can, how can you go to a court and say have been, discriminated because of an AI? Firstly, you don't know which AI is used, so you don't know exactly. You have to frame it, what kind of rights has been impacted, and then where are you going? Most of the people don't know. So this is the last recommendation that people told us about what should be done. So that's it.
Good afternoon, and and thank you for the invitation and for the opportunity to describe and present some of the projects I'm involved in the last years. And I am part of the JustTech, which is a research group of the National Research Council, which works on several projects related to the application of ICT and AI in justice, and basically on access to justice. And discussing with my colleagues in this panel when we were organizing this discussion, and we realized that we have a fil rouge between all these projects, and also a fil rouge between all the presentations that we have listened since now, which is participation. Participation of stakeholders, or participation of all citizens that are in some way affected by this kind of development in several forms. And so today I will try to describe very briefly some of the projects that I mentioned, but trying also to underline which participative activities have been implemented and how they affect the results of the project. The first project I want to present is a link, which is a European co-funded project, linking information for adaptive and accessible child-friendly courts. Basically, the idea is to study and try to find a way to reduce the barriers for the participation in criminal proceedings of children and children with disability. And the idea has been first to study how is the situation in some European countries through the involvement of stakeholders in order to map several aspects. So first of all, the obstacles of victims' access to justice, and basically vulnerable victims, the limits of justice system adaptation to vulnerable victims' needs, and best practices in EU related to the strategies to overcome this kind of barriers, and the opportunities provided by ICT and AI for improving access to justice. So, which participatory tools, let's say, have been used? First of all, the classic interviews, focus groups with justice professionals and support services, as well as focus groups with policymakers, and the use of expert monitoring on the activities and the results of LINK. This basically at the end of the project. And some training activities in which we provided to justice professionals information on how to adapt the procedure in order to accommodate the needs of vulnerable victims, and above all children and children with disability, victims of crime, and also children advisory boards. So we organize this kind of focus groups involving children, and in Italy, above all, involving high schools, and in which we try to understand from them a lot of things about the project and also about how they perceive criminal justice in the country investigated. And with the involvement of stakeholders, we had the opportunity also to design a blueprint for the creation of a sort of case management system that can allow to connect all the operators, justice professionals and support services which are involved in the procedure for victims' access to justice and the protection of victims as well. Another project is Seveso, which is called Support Eco-Victims, Strategies and Tools for Supporting Rights and Compensation of Environmental Crime Victims. Basically here the idea is to study how the system in Italy, the justice system, provides tools for the access to justice of victims of environmental crime. Starting first with an analysis of context in order to understand which are the barriers to the access to justice of this typology of victims, and with the idea also in this case of studying and exchanging good practices and enhance the cooperation among the national authorities which are responsible for the access to justice of eco-victims. And here we have the three milestones, let's say, of the project, which goes from, let's say, a more contextual analysis toward an online support, which is a more, let's say, applicative stage of the project, and then I will also explain what is the eco-justice restorative activity. So first of all, in terms of participation, we have also in this case the involvement of stakeholders in order to understand how in practice works the legislation for the access to justice of eco-victims. And also we have a sort of citizen science activity where we provide through the Seveso website the possibility for citizens who have been affected by, let's say, an issue related to an environmental crime, both in terms of health and in terms of criminal proceedings, to provide information on that. And through we can try to understand which area are more affected by this kind of issues. And third, we have a project in two, let's say, important locations for environmental crimes in Italy. A project of participative democracy slash restorative justice activity in which we try to combine these two methodologies, first in order to put at the same table both the author of crimes or the author of the environmental damage and the victims of crime, and this is the restorative justice stage, and then also in order to propose solutions for overcoming this kind of crisis. And this is more related to deliberative democracy, participation, and strategy. This is the flyer of the first meeting that has been held in Taranto, which is a symbolic area for environmental crime in Italy, and which allowed us to select and try to understand who can participate to the restorative justice and democracy and deliberative democracy activities. And this is for Seveso. And then I would like to present MetaJust. I'm not sure if I'm running late, but I will try to be rapid. Okay. MetaJust, Shaping Justice in the Metaverse. Okay, this project is a nationally funded project in Italy, and basically it explores the potentialities offered by the metaverse and the metaverse technology for the provision of services by the public administration, but also the justice system. And it is based also, in this case, on a contextual analysis of how the metaverse has been evolved in the last time, and also how it has been applied for the provision of services by public administrations, very rare to say. And but the idea is to apply this knowledge in order to understand, in order to create a sort of virtual courtroom, not a sort, a virtual courtroom, which will be experimented and tested for training. And training is, let's say, for us, the participatory activity that really characterizes this project. And also in this case, we have a contextual analysis with involvement of stakeholders, which allowed also requirement gathering activity that I will explain soon after. And then with the virtual court implementation, we will have a more, the participative tool here is related to training. We'll use the tool in order to train justice professionals in a faculty of law in Italy, with the idea of using the tool for mock hearing, for legal clinics, what is called legal clinics. So that they can use the system in order to interpret the role which they maybe will interpret in their work activity, like the judge, the lawyer, or the court staff, etc. So basically, the idea with the involvement of stakeholders has been to understand how a court room works, are how a court hearing works. And I think I'm happy to present this project here because the implementation of the Cyberjustice Lab courtroom has been very inspirational for this project. In fact, we started as well with the analysis of the rules which comes from the Constitution, from the law, or from practices that discipline the use of a courtroom and in a hearing, and basically which discipline also the roles of the actors, their position in the room, the possibility that they have to use the room and all their facilities. And since we are connected in some way with some projects related to the participation of vulnerable victims in crime proceedings, we expanded the virtual courtroom with the creation of a virtual protected room where for the audition of vulnerable testimonies, the classic protected room with the one-way mirror, actually. And here I will show you some of the pictures of the virtual courtroom. Okay. Finally, this is the final one. AI tools to design and enhance access to justice, coordinated by the University with other partners around Europe. The idea here is to apply artificial intelligence in order to create a model that will support lawyers as well as self-represented litigants in cases related to labor law, and in particular dismissal cases. And also in this project, the participatory tool has been important since we started with the analysis of 6 court systems with involvement of justice professionals and policymakers in order to understand first the level of implementation of digital tools in courts, the level of acceptance of the introduction of AI tools between justice professionals, and also the perceived risks related to the application of these tools, of AI tools, for the digitalization of this kind of procedures. So, thank you.